Hi everyone, and welcome to our webinar on protecting your business's most valuable asset, your IP. My name is Sophie Pemberton and I'm an associate in LegalVision's trademarks team. I'm joined today by my colleague Rebecca Wood, who is the practice group leader of LegalVision's dispute and litigation team. Before we begin, just a couple of quick housekeeping items. So following the end of the webinar, you'll all receive the recording and slides in your email. Please feel free to submit your questions in the chat box as we go, and we'll answer them at the end. And lastly, please complete the feedback survey after the webinar so that we can continue to offer you valuable content. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your IP, contracts, or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today, we'll be discussing your business's intellectual property and why it can be its most valuable asset. We're going to run through some different forms of IP and the steps you can take to ensure your IP is protected. Lastly, we'll touch on what happens when your IP is infringed by a third party and how you can enforce your rights. So to begin with, Rebecca will start by discussing what your business's intellectual property actually is and the different types of IP assets your business can own.
Great. Thanks, Sophie. Look, a lot of people talk about intellectual property and owning intellectual property, but not really able to sort of, I guess, identify what is their company's intellectual property. So it's a really good place to start. So broadly speaking, intellectual property refers to the creations of the mind, so inventions, designs, logos, names, artistic works. So it consists of the intangible property of your business. It can include software code, songs, t-shirt designs. It can be quite broad. But IP that you create provides you with the exclusive right to use or authorize the use of your intellectual property and prevent others from exploiting your intellectual property and rights or avoid creating confusion in the marketplace. There's a number of types of intellectual property rights that exist, especially from a commercial perspective. So these are patents, so inventions, trademarks, so our company's registered names, logos associated with their brand, copyright, which is original artistic works, and designs. So as I've outlined, patents protects inventions and innovations. Trademarks is aims to protect your company's branding. Copyright will protect your company's original works, so your publications, your products that you might be manufacturing in terms of unique designs, imagery, and design registration protects the visual appearance of certain products. So if you have a unique design, you should perhaps consider getting a registration to protect that design. It's really important to understand that intellectual property rights vary from country to country. And so there might be different definitions of what constitutes a copyright or a trademark or design in different countries. And so if you have intellectual property rights, you need to understand where you can register those rights or if they need registration at all. So for example, in New Zealand, some forms of intellectual property right don't require registration. Now, Sophie's going to touch on the value of protecting your intellectual property before we explore some of the forms of IP in more detail.
Thanks, Rebecca. So the value of the IP that your business creates and accumulates can be really immeasurable. As your IP is an intangible asset, it forms a significant part of the overall goodwill of your business. And this closely ties to the reputation your business develops over time. So as a result, protecting your IP is essentially one of the key stepping stones to building your reputation in the market. Some forms of IP protection are automatic in most countries, such as copyright, like Rebecca mentioned. But on the other hand, things like trademarks and unique designs can be registered with the Intellectual Property Office of New Zealand. And this affords you greater rights and protection. Registration essentially ensures you obtain exclusive use of your trademark or design in your industry, and it opens avenues for taking action against copycats. In addition, if your business has invented a novel product or formulation that provides a unique function, you can consider applying for patent protection so that third parties can't ride off the coattails of the time and resources you've poured into your invention and dilute the market with their imitations. Protecting your IP can allow you to then also commercialize it in valuable ways, such as by licensing the rights to use your trademarks or patented invention, or to receive royalties for reproductions of your copyright work. If you're planning to franchise your business, you'll also want to ensure you've protected your IP appropriately to ensure you have maximum control over how your third parties will use your IP. On top of this, if you're considering raising capital for your business, or perhaps you have a long-term exit plan, one of the first things investors and purchasers will check as part of their due diligence is whether your business's IP has been properly and adequately protected. So we'll now go into a bit more detail about some particular types of IP, and Rebecca is going to start by explaining copyright.
Great, thank you. Look, copyright protects original artistic, literary, musical and dramatic works. So this can include books, movies, songs, software code and other creative expressions. Copyright does not protect ideas, but the creative expression of those ideas. Copyright grants exclusive rights to reproduce, distribute, display and perform the original work. Copyright is an often underappreciated source of intellectual property. And can be very important to protect your brand assets. So copyright can protect your logos, slogans, marketing material, website content, and other creative expressions that you have created to associate with your brand. In New Zealand, copyright automatically subsists in the original works as soon as it's created. So what this means is that copyright protection arises automatically without a need for registration or any other formalities. So as long as the work is original, it exhibits a sufficient degree of creativity, which is a fairly low bar, it will be granted copyright protection. So whilst registration is not necessarily required, you might want to consider putting other people on notice that you claim copyright over your works by using the copyright symbol. So this is the C in a little circle. The year of creation, the copyright's owner name, and this is just a tool to make sure that you're letting the world at large know that you own copyright over that particular item, and is a great way of deterring others from exploiting your intellectual property rights.
Great. Thanks, Rebecca. So I'm going to now touch a little bit further on trademarks. So trademarks are essentially signs used by traders to distinguish goods and services in the marketplace. So this can include names, logos, slogans, and even sounds, movements, scents, colors, tastes, really anything that a business uses to identify themselves in the market or that's used as a badge of origin for certain goods or services. For example, some really common trademarks that have become recognized icons of their respective businesses include the Apple logo, the Nike tick, and the McDonald's golden arches that you can see on the screen now. These types of logos are what commonly spring to mind when you think about trademarks of a business. But keep in mind that your trademarks can also include non-traditional signs of your business, such as smells, shapes, or colors. For example, Cadbury has registered their particular Pantone colour purple in relation to chocolate products. And recently, a gin distillery attempted to register the particular smell of their gin products in New Zealand. And in the application, they described the trademark as a scent comprising the smell of the rainforest of the west coast of the South Island of New Zealand. So a critical realization is that your business is actually using certain trademarks from the moment you start trading or promoting your goods and services. The important next step you should consider taking is registering those trademarks so that they're protected. It's a common misconception to think that you are trademarking your brand name when you are registering your brand name as a trademark. In fact, it's already a trademark if you consider it a badge of origin for your business. And the registration process essentially just provides you with rights to take action against others who may copy your brand name who are providing the same or similar goods and services. However, it is important to note that some trademarks are not capable of registration. So for example, if your trademark is generic, descriptive, scandalous, or confusingly similar to another trademark already on the register, it might not meet the requirements for registration. So now that we've talked a little bit about some particular types of IP and how you can go about protecting your IP, Rebecca is going to discuss how you can actively monitor the marketplace for infringement.
Great, thanks, Sophie. So it's important to firstly understand what types of intellectual property you have, and then once you know that you have it, it's important to understand that you need to actively monitor for infringement. So what does this mean? So it means that you've got to be on the lookout for copycats or potential trademark infringement and take steps to protect your intellectual property. So how could you do this? So firstly, undertake regular searches. So this might include searches on just your Google search engines, look on social media platforms, online marketplace, industry-specific websites to identify any unauthorized use or similar trademark designs, copyright material or inventions. So be aware of who your competitors are. Are they promoting their business in a similar way to your promoting yours? It might be a good just to keep an eye on your competitors to make sure that they're not doing anything that's infringing your intellectual property rights. Make sure that your trademarks are registered, but also conduct regular searches on the trademark register to see if any brands are trying to apply for trademarks that might infringe on your brand. You can also engage brand monitoring services, or you could engage a firm like LegalVision to assist with marketing, monitoring the marketplace, the trademark register, both international and domestic, to assist with identifying similar brands or potential infringement of your rights. Lastly, make sure that you're aware of consumer feedback. So on social media, look to the comments to see what your audience is telling you. They might be able to notify you of copycats in the marketplace, and you should take swift action. Ideally, you want to avoid disputes about infringement. But Sophie's going to talk about and share some quick tips on putting third parties on notice of your rights.
Yeah, so an easy and quick way that you can put competitors and consumers on notice of your IP rights is by displaying the appropriate symbol next to your trademark. So just like Rebecca touched on before about copyright. For trademarks, the TM or R symbols are used to communicate to potential infringers to tread with caution, essentially. The TM symbol is used when you want to claim rights in a trademark, and this can be used actually any time before registration. So if you're yet to apply to register your trademark, or you have a pending application with the Intellectual Property Office of New Zealand, you can use this symbol to show the public that you consider the mark to be a trademark of your business. However, the R symbol can only be used on trademarks once they have been registered, and it's actually an offence under the Trademarks Act to use the R symbol on an unregistered trademark. So it's important you don't use this before your trademark achieves full registration. If your trademark is registered, it is then particularly important to display the R symbol, as this can serve as a way to put competitors on notice of your registered rights and deter third parties from potentially infringing on your trademark. It can also seriously improve your business's professional image and reputation, and acts as a warning that you take your IP protection seriously. So Rebecca is now going to explore some other methods of IP protection your business can take, starting with assessing your business structure.
Great, thanks, Sophie. Yeah, so there's a few key steps that you should consider taking in your day-to-day business to ensure that you're protecting your business's intellectual property as much as possible. If you're in the startup phase, it's especially important to put in place mechanisms to set yourself up for success. But once you're an established trader, monitoring and protecting your IP should be a constant consideration. So first, having the correct business structure in place is really important to manage your risk as a business generally, but can also be quite useful in protecting your intellectual property rights, both registered or registrable or unregistered. A dual company structure is a really good tool to use here. So typically in a dual company structure, the shareholders will hold the shares in a holding company or known as a parent company. And the holding company will be the 100% owner of a subsidiary or an operating company. The operating company will, for all intents and purposes, be the company that carries on the day-to-day business. It will enter into contracts with consumers, suppliers, and supply the goods and perform services. It's the holding company that will hold the assets of the business, and particularly the intellectual property. The holding company should license the IP to the operating company through what we would call an IP licensing deed, which will give the operating company the rights to use the IP. So if something goes wrong, a company's liability will not extend to the group companies, and therefore the assets, including the intellectual property, will be held by the holding company and kept safe. Sophie, turning over to you to discuss some other protections.
Thanks, Rebecca. Yeah, it's also important to consider how your IP is protected when it's created by your employees or contractors, because generally anything created in the course of employment belongs automatically to the employer. So to enhance protection, you can consider including some specific IP clauses in your employment contracts or contractor agreements, which will clearly outline who will own the IP that is developed in the course of your working relationship. If you have departing employees or contractors, it's also a good idea to remind them of any applicable post-termination restrictions upon their exit from the business or the contractual relationship. Another way that keeping your IP confidential and protected can be achieved is through contracts such as non-disclosure agreements. And some specific IP and confidentiality clauses in agreements with third parties. For example, your manufacturer or distributor. Non-disclosure agreements, or NDAs, in particular, can be used to protect your IP when you're still in the early stages of establishing your business and creating your IP. They're designed to essentially protect you when you're sharing commercially sensitive information in the course of doing business. So, for example, let's say you have a new product that you want to bring to the market. It doesn't meet the requirements for a patent, but it's still something that hasn't been seen in the market in New Zealand before. And you want to engage a manufacturer to manufacture the product for you. But of course, you want to make sure the manufacturer doesn't like your idea so much that they decide to create it for themselves. An NDA would prohibit the manufacturer from using any information that is shared with them, such as your product idea, for any purpose other than your discussion.
Great. So look, most commercial relationships will involve some form of intellectual property, and so it's really crucial to include IP clauses in your contractual arrangements. These clauses will set out any rights in any pre-existing intellectual property. So that is the IP that each party brings to this arrangement. Who will own the IP rights in any new IP that's created as a result of the contract and the arrangement, and how it can be used. The IP clause should also set out any licenses that are being provided in relation to each party's intellectual property rights, any restrictions on the license. So for example, if you're a developer who's been engaged to develop an app, you might want a license to your client's pre-existing IP, which would include their ideas, to be able to develop the app that would meet their specifications. Finally, keeping in mind that time is of the essence when seeking to protect your intellectual property rights and preventing the misuse of IP rights or confidential information. Any delay in acting can be a bar to injunctive relief or potential enforcement, which we'll discuss now.
Great. So now that we've talked about registering and protecting your intellectual property rights and monitoring for instances of infringement in the marketplace, we'll now talk about what you should do if or when you come across someone who you believe has infringed your IP. Generally speaking, the first thing you should not do is get in contact with that business. You'll need to first monitor the activity of the other business and collate as much evidence as possible. So this might include, for example, taking screenshots of the infringement online or documenting any instances of confusion between your brands. Once that's done, we recommend speaking to an IP lawyer to assess your legal position. And the benefit of this is to understand if there are any gaps in your protection and whether the other business may actually have any counterclaims against you. Your lawyer will also review the infringing material to assess whether you have enough evidence to substantiate the claim. If it's been established that there is a claim, that's when you can take action. There are several formal and informal ways of taking action, which we'll discuss in more detail in a moment. But as Rebecca noted before, you should consider taking action as soon as possible after identifying the infringement. The reason for this is because the longer you wait and the longer the other business uses the infringing trademark, design, or copyright material, the stronger the other side's defense will become. So just before I hand over to Rebecca to discuss some of the methods of enforcement, I just thought it'd be important to reiterate that registration of your IP can play a key part of the enforcement process. Once your trademarks or designs are registered, you are assumed to be the rightful owner. And so you don't have to continuously jump through hoops to prove that you are the original owner and developed the intellectual property in the first place. Enforcing registered trademarks against copycats is also much easier under trademark law compared to enforcing unregistered trademarks by other means, such as via New Zealand consumer law or passing off, which have much higher and stricter thresholds of proof and require court action to be initiated. Registration of trademarks also offers you a powerful defense to claims of infringement that may be brought against you. Without a registered right, it may be much more difficult to attempt to prove in court that you were the rightful true owner or started using the mark before another party. So now Rebecca will take us through some of the informal ways you can enforce your rights in the first instance, and then discuss some of the more formal methods, such as litigation, to defend your IP rights.
Great. Thanks, Sophie. So look, there are a number of ways that you can try and enforce your intellectual property rights. And the first way to explore might be an informal route, especially to begin with. And there are many reasons why an informal route might be the best way for you to enforce your intellectual property rights. So firstly, what action you should take will depend on the nature of the infringement that you've discovered, how much it's worth to you, and what is the impact that the infringement of your intellectual property will have on your business. So obviously, if it's a high value matter and there's a real risk of damage to your brand, you might want to start with more formal routes such as court proceedings. But hypothetically, if it's a lower value infringement, or it's obvious to you that this might be an accidental infringement, just contacting the infringing party and clearly explaining your ownership rights and the source of the infringement of your rights, requesting that they cease and desist from the infringing conduct or modify their branding to avoid confusion can be just a great way to resolve a potential dispute. When you're contacting these parties with your evidence of infringement, it's really good to detail the impact of their infringement on your intellectual property right. And particularly if you think that there's a risk of consumers getting confused, it's really important to outline how that confusion can take place. Now, if contacting the infringing party is perhaps not the right option for you, there are some other more formal takedown options that might be available to you. So, for example, there are via the social media platforms and online marketplaces like Etsy, they have mechanisms in place to address intellectual property infringement. So, for example, if you're selling, a creative piece on Etsy or promoting your works via Instagram, both of those platforms will have a way in which you can report intellectual property infringement, and those infringing accounts will be shut down until you've resolved, or the post removed until the issue of infringement has been resolved. So it's a great way of getting some swift action. domain name disputes. So you can also consider the administrative bodies that administer domain names as an alternative to litigation. And these formal platforms can operate a process for the parties to raise and resolve domain name disputes without having to commence formal litigation. So if these informal options are not working for you, they're not getting you the desired outcome, then you might need to consider whether or not you need to up the ante a little bit and consider commencing court action. So if you identify a business that's infringing your intellectual property rights or copying your IP, you need to consider whether or not you want to commence court proceedings. You might want to allege that this copycat business is also engaging in misleading and deceptive conduct, which is a breach of the consumer laws in New Zealand, or passing off. And so what this means is the copycat, in addition to potentially infringing your intellectual property rights, is essentially trying to trade off the goodwill that you've established in your brand, or misleading customers into believing that this copycat business is associated in some way with you, and in essentially diverting business that should be coming to you to them. So before you commence proceedings, it's important to engage a lawyer to prepare a cease and desist letter, which sets out the formal demands that you need, that you want in order for the infringing conduct to cease, and perhaps make a claim for compensation or some other remedy. Now, this could be an alternative to court action, but also a little bit more serious than perhaps contacting the infringing party yourself. Now, a lawyer might be able to assist you reach some sort of compromise with this copycat. And this is sometimes what we would refer to as a coexistence agreement. So it might be able to negotiate the terms upon which you can both build your brands, but without infringing on each other's rights. If you do need to commence formal court proceedings, you can ask the court to provide you with the following remedies. So injunctive relief. So this is aimed at stopping the infringement from continuing. So it would be a court order that means that the other party has to essentially stop what they're doing and can never engage in that conduct again. You might be able to claim damages. So this would be a financial payment, being compensation for the losses that you've incurred as a result of the infringement, or an account of profits. So for example, if a copycat business has made profits as a result of infringing your intellectual property rights, will the court say that they shouldn't be entitled to that profit, and they can hand that profit that they've made over back to you. Now look, litigation can be a really costly process, so it's really important to weigh the risk and damage to your business reputation as a result of the IP infringement against the benefit and importance of protecting your IP rights. So you should get legal advice to understand whether or not litigation is the best option for you in your business, or what other options that you might have. And it's important to understand that you may be able to pursue legal action even if you haven't got registered trademarks or designs. So getting advice on what your intellectual property rights are is really important. Just as a final note, it would also be really important to set aside some room in your budget to make sure that you've got the money to spend on enforcing your intellectual property rights if your IP rights are really important and integral to your business.
Okay, so that concludes the main part of today's webinar, and we hope you found it informative. You might also find our free publication on Trademark Essentials helpful, and you can download it from the handout panel or by scanning the QR code that's on the screen now. We also have an upcoming event that may be of interest to you. It's on terminating employees, best practice for avoiding personal grievances. And this will be held on Tuesday, the 14th of November at 12 p.m. You can register at the link on the slide now. So we're going to answer your questions shortly, and while you submit them, we'll take a minute to tell you about our membership. So a LegalVision membership is designed to essentially be a one-stop shop for all of your business's legal needs, and it offers you an affordable way of essentially having your own in-house legal team. As a member, you get access to unlimited advice consultations with our lawyers who are experienced across a wide variety of areas of commercial law. And you also access things like unlimited drafting and reviews of contracts, employment support, and relevantly, unlimited New Zealand trademark applications. So it's all included in the membership. If you'd like to find out more about membership, we can organise a time to meet and formulate a bespoke membership plan for you. So now we will turn to answer some of your questions.
Great. Well, look, I can just jump in, Sophie. I've got a couple here.
Yeah, great.
So the first question we've got is, would trademarking my product name be sufficient, or do I need to obtain a complete patent? So these are two very different types of intellectual property. So yes, trademarking your product name would be important. So that will help you protect the brand of the product that you're making. A patent is an intellectual property registration to protect the actual product that you might have invented. So two very different things. And in your business, you might actually require quite a few different sources of intellectual property. So understanding the intellectual property rights that you have in your business is really important. So if you'd like to have a chat with us after this seminar about your particular needs, feel free to take up the opportunity for a webinar. The next question that's been submitted is, I am concerned about someone commercializing my idea, which is purely made for helping and connecting people in the community. What can I do? Look, this is a tough one because essentially there is no intellectual property in an idea. So what you could do is ensure that you have got the intellectual property around your brand protected. So that might be identifying the copyright in the publications that you've got on your website content, making sure that you've got registration in your trademarks. But essentially, if there's another business that's essentially copycatting your idea, you might have some rights in respect to misleading and deceptive conduct if there's any confusion in the marketplace between the two businesses. But unfortunately, again, there's not a lot you can do to stop your idea being copied, but you can take steps to make sure that there's no confusion. Sophie, this might be a question for you. How do we go about international trademarks or internationally protecting your brand?
Yeah, okay, good question. So really, trademark protection takes place on a country-by-country basis. So the first thing you'd want to start thinking about is your target markets and the countries in which you want to provide your goods and services. Generally, it's best practice to protect your brand by registering a trademark in all countries that you're trading or offering your goods and services. And mainly because the last thing you want to do is launch into a new market and find out someone else is already operating under that particular trademark or something similar already and providing similar goods and services. The other thing to note is there's no such thing as an international trademark, but there's two main pathways that you can take to apply internationally. So you can either apply directly to your countries of interest, and that will usually require you to appoint a local agent there. Or the alternative pathway, and the one that's most popular if you're looking at filing in multiple countries, is via the Madrid Protocol. So this involves filing one application that's registered with the World Intellectual Property Organization, and then it's sent off to the individual countries that you nominate for examination. Similar considerations would apply for patent protection, so you'd need to really get specific about your core areas of operation and the primary countries where you want to lock down your rights to your brand or invention. Copyright is fairly universally recognized, but as we spoke about earlier, you do need to register your copyright in some countries, such as the US, if you want to enforce your rights there. Generally speaking, international IP considerations are quite complex, and I'd recommend speaking to an IP specialist about your personal situation so that you're set up for successful international expansion, but also so that you're not infringing upon anyone else's IP overseas in the process. So,
great. I've got another question here on trademark registration. So just simply, how much does trademark registration cost?
Yeah, happy to jump in there. So Trademark registration fees are different in every country. So just how we were speaking a little bit about how there are different processes for filing overseas, and the filing fees will depend on the countries that you're looking to register in as well. So in New Zealand, the filing fees are relatively inexpensive. It depends on the kind of application you submit. Generally about 70 to 100 New Zealand dollars per class, and we can discuss how many classes you'd need in your application in a further consult. But overseas, the fees can really escalate, and so we can work with you to put together a plan depending on how quickly you're looking to expand, and go from there. But yeah, that's really kind of a more of a bespoke question, and we can more than happy to discuss that further and in a separate consult.
Great. Another question that's just popped in is, how do I protect the IP for a method of direction or instructions and the title of the method? So if this is a creative work, it could be protected by copyright. So for example, recipes are often protected by copyright. So I think it would just need a little bit more information about exactly what you're trying to protect, but I would suspect that copyright would be the source of the protection for what you're trying to create here. The next question we've got is, if the brand is an interactive digital online platform, would it be possible to protect its IP? I'm happy to jump in with the answer there. So look, certainly, absolutely you can protect your IP. So again, if your brand is, publishing content online, that might be protected by copyright. You should be protecting your brand by getting registered trademarks. So certainly, just because a brand is based solely online doesn't mean that it doesn't have IP protections. How do I protect the content of my ebooks? Great question. Again, copyright should come to save the day here. So a book would be an original artistic work and protected by copyright. So if you are published, you should speak to your publishers to make sure that if you're getting some good advice in relation to international protection of your copyright. If you're self-published, again, putting the copyright symbol and making it very clear that you are claiming copyright over the content of your book would be very important. How do I protect the IP of the content of my resources from being demonstrated? For example, creating tutorials and methods and the contents of the book. So the content of your books will be protected by copyright, and a substantial reproduction of that content would be considered an infringement of your copyright. So again, when you're publishing any resources, making it very clear that you're claiming intellectual property rights and copyright over the works would be very important. If another business is using a trading name which is similar to your legal and business name, is it best to get your name trademarked first before asking the other business to stop using your name? This is actually a really good question. Sophie, I might throw this over to you to start.
Yeah, absolutely, sure. So if you're in this situation, I mean, it's a little bit less than ideal. Obviously, you'd want to have got in first and registered your trademark so that you obtain exclusive rights. It is a good thing to look at starting to apply and start the application process to register your own trademark if you've also been using that name, that similar name for a period of time. What I would recommend though is, again, speaking to a lawyer, because there could be an instance where you are potentially infringing upon their intellectual property or their trademark registration if they have already registered their own, or if they've also been operating in the market for quite some time. So it's a bit of a balance here between, yes, registering and starting that application process to protect your own trademark, but also making sure that you're not continuing to operate in the same market where there is a similar brand that you are infringing upon. And also from a commercial perspective, you just want to keep in mind maybe the dilution of your brand if there's a bit of confusion in the marketplace there. Did you have anything to add to that, Rebecca?
Oh, look, I think that that's a great answer, and it's actually something that comes up quite often in my practice in particular. You know, generally, before you go ahead and start making allegations that another party is infringing on your intellectual property rights, it's really important to understand what are they. So, firstly, getting some legal advice on your position, but certainly if no one has registered that trading name, then it might be worthwhile making sure that you've got the registrations in place, so you're coming from a position of strength before you make any allegations. So yeah, I totally agree.
Great.
So the next question is, can you copyright a video? So certainly a video can be protected by copyright. But what you might want to consider is, you know, are you creating the video yourself? Is someone else creating the video for you? So if you're engaging, you know, a videographer to come and create some video content for your website, it's really important to make sure that you've got those IP license agreements that we discussed earlier in place to make it really clear who owns the rights to the video.
I think that's all of the questions that we have at the moment. We'll just wait for any last ones to come through in the next minute or so. Otherwise, we'll start wrapping up. You can also feel free to, again, if you submit your name to have a consult with us after this webinar, we're more than happy to run through your questions there if you prefer to address them in a private situation. So we can always do that as well. Just wait a few more seconds. I think we will. Yeah.
Yeah,
sorry.
yeah. Look, I've got a quick question that I'm happy to address, which is, you know, why do you need to, you know, trademark a name? So, you know, as we discussed earlier, it's really important to register your brand names and your logos as trademarks, because it's putting, you know, the world on notice essentially that you own the rights to those names. But it's also really important to understand that your brands and logos are also protected by copyright. So you've actually got some dual protection. So you know, a really great example is a company like Louis Vuitton, which has a really recognizable brand. So it will be protected by trademarks, but also protected by copyright. So that means that it can also stop counterfeit products from being manufactured where they're not necessarily saying that they're LV, you know, that we all know that they're just trying to copycat off the intellectual property in design of the fabric. Final question that's just popped through is, can you register online video communication tools? I'm not quite sure what the online video communication tools are, but let me just give you some thoughts. So if there is some source code in the online communication tools, that could certainly be protected by copyright. I don't think it would be something that could be registered as a trademark or a design. If it's a innovative invention, you certainly might be able to explore some patent rights. You know, this is a fairly specific question, and we'd be happy to address this with you in a consult to give you some further advice. Look, if we haven't been able to address your specific question, it's because it might not have been a great topic or question to explore in a seminar, and it looks like you're after some very specific advice. And so we would strongly encourage you to take advantage of the consultation so we can explore that with you. But likewise, we'd be very happy to discussing any of your intellectual property questions. We both love IP, so happy to explore those with you in further detail. So please take advantage of the consultation. Look, we're going to wrap up. That's all the time that we've got for, but thanks for joining us today. It's been great to canvass intellectual property rights and some of your really excellent questions. We would really appreciate it if you could just let us know your thoughts on the seminar by completing the 30-second survey at the end. And please insert your contact details to make sure that you can take advantage of that complimentary legal consultation to discuss how we can help you protect your intellectual property.
Thank you.
Thank you.